All right. I think we're still missing one or two people, but I'm gonna get started. So this is the process counterplan elective. Those of you who don't know me, I'm Anthony Trufanov. I think all of you probably know me. So the way this is going to work is I'm going to very briefly just introduce the idea of process counterplans, and then I'm going to go through the resolution basically, and I'm just going to talk about the different ways the different parts of the resolution can be used as bases for counterplan competition, and I'm going to give some examples of how that works. This is mostly going to be centered around giving a bunch of examples of process counterplans that have occurred historically, and kind of describing how those work. So if a particular process counterplan that I give an example of piques your interest and you want to see, for example, a file that is built around that counterplan, you can feel free to raise your hand and ask for that. And if I have the file, I'll try to show you something that demonstrates how the process counterplan works. Or if you just want to know more about how a specific process counterplan works that competes off a particular word, you can feel free to interrupt me, ask a question in the chat, whatever you all want. The goal of this is to be more of a conversation than just me ranting at you, although I can rant about this topic for quite a while. Okay, so before I kind of get into specific examples, so how do kind of process counterplans work in general? So what we're talking about when we talk about process counterplans is we're talking about counterplans that do the core component of the AF. So these are counterplans that, for the most part, right, encompass whatever the AF does. And if you were to summarize what the plan does, that same element would likely be in the process counterplan. But some peripheral element of how the process counterplan works would change relative to the plan. So for example, these might be counterplans that compete off of certainty. These might be counterplans that compete off of immediacy. So a delay counterplan would be an example of a process counterplan, since it would do the core component of the AF, but it would change something that is arguably part of the AF, which is the immediate action component of the AF. That's just some examples. Some typical competition arguments that are made for these counterplans revolve around the first part of the resolution, since the first part of the resolution is the one that's not specific to any plain text, and that is the stuff based on should. People typically argue that should means both certain and immediate. People say resolved means certain. People say the word the before the USFG means the entire USFG. People say substantial means immediate or certain. And so that's kind of the general argument style that we're talking about here. I'm going to throw in some examples that probably aren't strictly process counterplans, but that's generally what we're talking about. So the first body of process counterplans is the kind that applies basically regardless of what the topic is, and that's the kind that primarily competes off of these examples that I just gave: should, resolved, the, and substantial. And these counterplans make very basic competition arguments based on just the general ideas of immediacy and certainty. So one of the most basic kinds, and this is kind of the thing that I think most people think of when they think about process counterplans, is the idea of a consult counterplan or a consultation counterplan. And so consult counterplans basically do the whole AF, but only on the condition that some external actor agrees that the plan is a good idea. And typically they say that they would implement any modifications that this actor proposes. So typically when we talk about consult counterplans, and over the past few years, we've had a couple of international topics. And in those contexts, what we're typically talking about is we're consulting our allies. We're consulting, for example, NATO. We're consulting Japan. Those are popular examples of countries that we frequently consult when we're neg. On domestic topics, the consultation counterplan is a little bit trickier because it's not usually the case that there's good evidence that connects domestic action to, you know, other countries in the way that other countries are reacting, in the same way that one could plausibly argue that consulting about foreign policy would kind of boost NATO's level of support for us or something. And so domestic topics have a sort of different slate of consultation counterplans that typically occur. One is the regulatory negotiation counterplan. The way that one works is you have the federal government start this regulatory negotiation process where they invite a bunch of businesses and stakeholders to the table and basically ask them how they want the plan to work. And the counterplan argues that the process of consulting all of these people brings all of them on board, and they would all agree with the general outlines of the plan, but they would produce favorable kind of changes that make the plan work better. And on top of that, it diffuses political opposition, which is good for politics, and it's good for avoiding court clog, and it sets a positive precedent for doing regulatory negotiation that's binding, which spills over to other areas in a way that's good. So that can be thought of as the consult businesses counterplan. Another example of a consult counterplan on domestic topics is the referendum counterplan. So all of you probably know what a referendum is, but the referendum counterplan basically just does what you think it does, which is it puts out basically a questionnaire for everyone in the US to answer. And it's kind of like a direct democracy type of thing, where you literally ask the people of the US to vote on whether they support this particular policy. And if they do, you would enact the plan. You would argue that they do, and you would argue that the precedent set by doing direct democracy in this area is good. It galvanizes people's engagement. One argument about the referendum counterplan is that it causes more turnout to occur, which is good because turnout on election day is good for making it so people come to the ballot box, and you could argue that that helps Biden win the election. There's also a counterplan that is likely to exist on this topic specifically, which is the consult natives or consult tribes counterplan. And this counterplan would argue that criminal justice is a fundamental question of sovereignty, and that is something that tribes should be able to weigh in on, because that is something that kind of improves tribes' ability to self-govern and kind of determine the course of their own administration of justice within their territory. And you could also argue that the spin-off effect of that is good, and specifically that it complies with something called UNDRIP, which is the UN Declaration on the Rights of Indigenous Peoples, which can be good for a variety of reasons, including solving separatism globally, secessionism globally, and solving human rights credibility. Now, that's not to say that there are no international actors that could be consulted on a domestic topic, and there are still some international actors which are relevant specifically to the context of kind of criminal justice, and specifically as they intersect with human rights. So one that you might have heard of that's fairly common is the International Court of Justice counterplan, although that one applies a little bit less directly, since the International Court of Justice is primarily about interstate relations. You could say that you could counterplan to request an advisory opinion from them, and then have them, provide some input and then do whatever they say is necessary to do. But again, that one's not as directly relevant. More directly relevant is the International Criminal Court counterplan, which would say that, that's a forum that's typically designed for trying war criminals or human rights abusers. And so that counterplan, you could consult the International Criminal Court about whether not doing the plan makes officials in the United States government human rights abusers. And you would read arguments about why the credibility of the International Criminal Court is good, and that would kind of be your net benefit. Another example that is probably relevant and familiar to the people, at least who are in the AT lab, since you all were writing the MLATS AF, and it's kind of very intertwined with this specific area, but the European High Court, or the European Court of Justice, is the highest kind of judicial body in the European Union. And especially on transboundary data issues, which is kind of the area which the MLATS AF is very concerned with, the European High Court is obviously very relevant, because kind of the whole impetus for doing the proposals that are in the MLATS AF are to kind of adapt to the recommendations or the requirements of the European Court of Justice for transboundary trade. And so one counterplan that is relevant in that area in particular is to consult the European Court of Justice to determine what they want the plan to be. A final example of a consult counterplan is the UN UPR counterplan. This is the UN Universal Periodic Review. And so that is a thing that happens every 4 years or so. The next one is coming up in November of 2020. And what it basically does is every once in a while, it audits the state of human rights in every single UN member nation. The idea of it is to determine relative standing and provide an impartial input into how human rights are unfolding in a variety of different countries. And so this counterplan, you would ask the UN UPR to specifically speak to the question of the plan, or to specifically speak to the question of criminal justice reform, and you would implement the recommendations of the UN UPR. And the result of that would restore the credibility of the UPR process, which is good for human rights. So that's kind of some examples of the consult counterplan area. Another area of counterplans that is relatively common, but this one actually varies a lot more from topic to topic, is recommendation counterplans. Recommendation counterplans also compete off of certainty and immediacy, primarily, although I would argue that they compete a little bit more firmly, since no part of the counterplan would fiat that the plan ever occurs. These are counterplans that have an actor that is external to the one doing the plan do something to ask for the plan, or to kind of raise the pressure for the plan to occur, and then you would argue that results in the actor who does the plan doing the plan, but the prior action by that, first step makes it better somehow. One example of this is the commission counterplan. This is the one that's kind of the most static from topic to topic. And the idea of this is the federal government frequently creates these commissions, which are basically bodies of experts who are tasked with discussing a specific area and arriving at a set of policy recommendations. And one common argument is you create a commission over the area of the plan, they recommend the plan, and then you argue that the existence of an expert commission diffuses the controversy around the plan, which results in it being enacted and diffuses the link to politics. Since policymakers have kind of punted on the political costs of having to advocate for the plan, they have forced another entity to take on those costs for them. On more scientific topics, there are a variety of science-related funding priority counterplans that can mostly interact with the forensic science area of this topic. One is the National Academies of Science, or National Academy of Sciences. I'm not sure which it is off the top of my head. But so the national academies make recommendations very frequently. And so they can make recommendations or funding priorities or guidelines for the area of forensic science. And the net benefit there would be both NAS credibility, and there's a lot of literature in the forensic science area specifically about boosting the predictability of the funding stream. And an important step for that being having an entity that sets long-term funding priorities. A related argument that exists on more exploration-focused topics, which is primarily exploring the oceans and exploring space, is the Decadal Survey, which is a policy document that is published by the national academies in those areas, which basically outlines the set of scientific priorities in that area for the next decade. And that kind of gets at the similar discussion of long-term funding stability, and some of that literature will likely overlap with the people calling for more long-term funding for the area of forensic science and exploration of new forensic science research. Another example in the area of sentencing that is likely to occur on this topic is, those of you who have researched sentencing have probably come across this, but not really thought of it as potentially a counterplan. But there's sentencing requirements. So that typically takes the form of like mandatory minimums, right? So mandatory minimums are a law that says judges are not allowed to give below a specific sentence for a particular crime. There's also other ways that the federal government shapes sentencing decisions, though. For example, non-binding sentencing guidelines are the primary way that the federal government shapes decisions. And this is primarily, these are documents that are published within the Department of Justice, and they contain recommendations for how judges should go about doing sentencing. And that is arguably a less intrusive or a less coercive way of altering the way that the courts go about sentencing, which could be good for judicial independence, it could be good for federalism, or at least better for those things than the plan. So I'm not going to talk about a lot more recommendation counterplans because I kind of think this is an area that changes a considerable degree from topic to topic. So those are what I think are going to be the primary topic-specific recommendation counterplans, but ones that have historically occurred, there's been a variety of them, but I don't really think that they're going to be as relevant on this topic as some other historical process counterplans. A third category of process counterplans is the study/research/impact assessment style counterplan. And these counterplans are all, they have the same general structure, which is they create some kind of professional entity, or they use an existing professional entity. They submit the plan for review to that entity. And then if that entity comes back with the conclusion that the plan is good, then you do the AF. And that benefit is that following the rigorous process of the so-called impact statement is good because it sets a precedent, because it makes the plan more credible, etc. So some examples of impact assessment or impact statement counterplans that might be relevant on this topic. Race impact statement is a thing that GBN said a bunch on the education topic. That's just basically check if the plan's racist, make changes to make sure that it isn't, any risk that it is a D rule. There's something called a human rights impact statement, which I believe the last time that was more relevant was the immigration topic. And so that one, same idea. You check if the plan is bad for human rights. If it is, you don't do it, or you make modifications to make it so that it isn't. Some other examples that are more, or I guess less common over the course of many topics, but have come up a bunch on several specific topics, are the federalism impact statement counterplan, which checks if the plan is bad for federalism. and the Constitution Impact Statement Counterplan, which checks if the plan violates the Constitution, basically submits it for internal executive review. And it says that violations of the Constitution are really bad. One that is a really common example from topic to topic of this that may or may not be relevant in this topic, but teams often find a way. Like they found, there was one article about this counterplan in immigration, and it was read a surprising amount based on that. But that's the Environmental Impact Statement Counterplan, or the NEPA counterplan, which is the National Environmental Policy Act counterplan. And so that one, same general idea. It's a little bit more common since that's something that actually happens all the time. But the idea of this is to basically check if the plan would hurt the environment in some way. And this is an existing law that mandates that the federal government reviews whenever it spends a bunch of money on something if it destroys the environment, and that, you know, has an environment net benefit, which could be DFO according to Holland, or it could be other things. Another category that does not, well, actually, I'll revisit this category later. The last kind of two sets of things that compete off of resolved, the, should, and substantial, and that kind of stuff is counterplans that try to use the leverage of the plan to get other stuff to happen. The first kind of counterplan that falls under this is the QPQ counterplan. So this is, you offer the plan to someone else as an incentive to do a third thing. You say, they say yes by doing the third thing, and then you do the plan. And it competes because they might say no, and then the plan would not happen. So in this world, the plan kind of functions as a carrot. It's, you're offering something that somebody else wants. And so this could work with a subset of affirmatives that mostly focus on funding. So stuff that funds elements of the criminal justice process, stuff that toughens sentencing on particular areas, and stuff that funds increased research into forensic science, I would say, are primarily the areas where this is relevant. And in this area, the idea would be, so the plan is something that the states want. So when you offer the states to do the plan and then ask them to do something else, they would then do that something else. You read net benefit about that other thing, and you say that other thing is good. You can also do this strategy or this general structure with affirmatives that states wouldn't like, or affirmatives that other actors wouldn't like, to which you're, to whom you're making the offer, right? So this is the threatened counterplan, which has a similar competition argument, but it has the opposite net benefit. So it says you threaten the states or whoever. I think mostly on this topic is going to be the states, but you threaten the states to do the plan unless they do something else. So you're like, I'm going to do this bad thing to you, which is the plan, which is this thing you don't want, unless you respond with some other policy change. You then say that the states would say no to that policy change, so the plan would happen, but you say that the threat, or using the plan as a threat, was good for some reason. It either sets a stronger precedent for a federal hand in bargaining over areas, it boosts the human rights credibility of the federal government because, the federal government's intervening with the states in a very highly public and visible way to try to use the stick of the plan to get them to do some other stuff. So that's kind of my brief survey of the resolved /the /should /substantial turf. Any questions about any of that? This is kind of the most vanilla layer of process counterplan discussion, I would say. No questions about that? Cool. Okay. So let's move on to some topic-specific stuff. Oh, do I have an example of the funding QPQ thing? Yeah. So, for example, if you... I imagine most of the actual literature about this area is going to be very topic related. So, for example, against an affirmative that funds forensic science at the state level, I think a reasonable response would be you offer funding to the states to do forensic science reform, and in exchange, they have to stop using private prisons. Was there a specific name for that survey related to the exploration-related counterplan? Yeah, the decadal survey. I might be pronouncing that wrong, actually, but it's this. Ben, does that example make sense? Nice. Okay. Sorry, I'm going a little quick because I have a ton of examples to get through since we're backfile checking here. Okay. So moving on from general stuff to topic-specific stuff. So we're kind of moving forward through the resolution. The next main term that we encounter in the resolution is enact. So what does enact mean? So obviously the agent component of the enact discussion has gotten a ton of airtime at camp so far, and we're all kind of familiar with the way that the word enact interacts with the competition debate with the executive, the competition debate with the courts, right? So, but there's some underlying kind of etymological components with respect to the enact debate that could be used to make some other counterplans more competitive. So part of that is there's a specific component of discussions about congressional enactments that is good, right? Or that is attached to the word enact. So you probably, I don't know how many of you have like taken US history classes that you have cared about or remembered things from. I'm roboting. Yeah, it did tell me my connection was unstable. RIP. Can you all like understand what I'm saying still? Okay, I cut out for 10 seconds. Good now? Okay, nice. Sorry, so what I just said was the word enact interacts not just with the agent discussion, but also with some process discussions that underlie kind of the substantive components of what we mean when we say Congress should enact something. So from US history, you might have heard of this from like the pre-revolutionary period when like the Brits were like taxing the American colonists. Have you heard of things like the Stamp Act? Maybe is vaguely familiar when the British Parliament enacted some taxes. Yeah, so that's kind of the origin of the intersection between the word enact and the agent debate, since basically what the US calls bills is in many other parliamentary structures in the legislative body called enactments or acts. And so that has more connotations than just the agent connotation, right? Because there's obviously the element that it has to be legislative, but it also, there's things that the legislature can do that are not enactments, right? That are not following the process of the Schoolhouse Rock, how a bill becomes a law, step-by-step sequence, right? So there's that set of considerations. There's also some process-related considerations that are a little bit more general. So one is that it actually has to be put in place, not merely potentially put in place, right? Because it's not enacted or it's not put into action if it has not actually been put in place, if it has only begun the process of being put in place. A corollary to this, which is how enact is probably going to interact with some of the counterplans that I talked about earlier, is that enactments have to be certain, because if something has not been put into action, it has not been enacted, or if something can only maybe be put into action in the future, it has not been enacted, right? So we've got some agent-related arguments that use enact as a basis for competition, but are not actual agent counterplans. One is judicial counterplans that are not the court's counterplan. These are primarily international judicial counterplans that fiat international judicial actors and then have them compel Congress to do something. So this is what I talked about earlier primarily. You fiat the ICJ or you fiat the International Criminal Court, and you have them declare the United States to be in violation of international, either general international law or international humanitarian law or international laws of war, if it's an affirmative about Guantanamo, for example. And then you kind of have them threaten to prosecute the United States, and then you argue that the US would say yes to that prosecution. There's also executive counterplans that use a specific executive process to generate a net benefit. So we've brought up a couple of these at camps so far. One is the pardon counterplan or the clemency counterplan, which has the executive use the pardon power or the clemency power to lighten the sentence of the people that would have been affected by the reform that is the AF. And you kind of use that to effectuate the same change to sentencing. And you say that reclaiming the president's pardon power in that way is good. Other examples that we have not talked about yet. One is the memorandum counterplan, which is also, it's similar to the guidance documents counterplan, which has gotten a little bit more airtime over the past couple of topics, primarily on education and immigration. And so this counterplan basically writes a little, it publishes a little note, which says, it has the executive publish a note that says, we have surveyed the layout of the law, and our intention is to enforce it and interpret it in the following way going forward. And that following way is the plan. And this has the benefit of, well, it's a couple of things. One is it's not a unilateral executive action optically in the same way that some other unilateral executive actions are, in the sense that it's not creating law. Its claim is that Congress has already passed a law that mandates something, and then the memorandum kind of declares the presidential interpretation of that thing. And so this appeals to the certainty of a statutory enactment, but it doesn't create a new statutory enactment because it has the president just do it through a memorandum. The cost of that is you're risking judicial review. So there's a better judicial strike down argument, since it rests on a literal interpretation of a law, which the courts could hypothetically overrule. But you're getting some, aside from the solvency benefit, you're also getting an additional internal net benefit, which is the APA bad net benefit. The APA is the Administrative Procedures Act. It's a law that was passed by Congress that governs a certain set of stuff regarding how the president is able to legitimately implement specific policy changes, such as memoranda. And by doing it abruptly, by doing it without notice and comment, which is basically kind of like the thing that I described for Regneg, but that's like something that the executive technically has to do whenever they promulgate a new rule. But by doing it without that, you're violating the APA, and you say the APA is, it's bad, it's undemocratic, whatever. Another internal executive counterplan is the impoundment counterplan. So impoundment is a thing that the executive can do to money that has been appropriated by Congress. Well, technically the president can't do it because Congress prohibited it using the Impoundment Control Act, but there's still some flexibility, and there's an argument that the affirmative or that the negative team can make that the impoundment counterplan's durable fiat would result in overruling the Impoundment Control Act, and you would say the impoundment power is good. Impoundment, I think I never actually said what it is. It's when Congress gives the president money, and then the president says, I'm not going to spend that money for a certain period of time. So basically, I'm going to hold on to that money. So let's say Congress has appropriated a bunch of money to the Department of Justice, saying the Department of Justice needs to prosecute drug offenses. And one way that you could approach decriminalization is through Congress, literally doing decriminalization. Another way you could approach is the president declaring it not to be an enforcement priority. And then this way would say, the president doesn't say anything about whether it's an enforcement priority, but simply refuses to spend the money that Congress appropriated for this purpose. And you say that the procedural precedent that is set by doing impoundment is good. There's some other agent-related counterplans as well. One is the court threaten counterplan. The court threaten counterplan is basically it's a common example that is invoked in the literature about interbranch bargaining. So this debate is one that occurred a bunch in the context of really the fight between Congress and the president about oversight, where Congress has a variety of sticks basically to get the president to do a certain set of stuff without, even in areas where Congress doesn't technically have the power to pass a law to like literally force the president to do something. And so the courts have a similar option, which is the threat of a binding ruling. So the theory here is that since all the branches of the government have a vested interest in protecting their own power, they never want the court to make a binding ruling on the substantive areas of whatever area the plan affects. And so the idea here is if the court threatens through some mechanism to make a binding ruling that compels Congress or the president to do the plan, then Congress and the president would do the plan themselves. And the strength of the threat is so great that out of an abundance of caution, they would also do other stuff to kind of convince the court that they're acting in good faith to stave off this kind of negative ruling for their authority. And so that's the court threaten counterplan. It can either target Congress, or it can target the executive, or it can target both. A final counterplan that competes off of enact is the private right of action counterplan. And this is a mechanism of courts counterplan that basically makes people within the government financially liable to citizens for not doing the plan. And so, for example, for sentencing reform, if Congress passed a mandatory minimum and the court was like, the mandatory minimum is bad, but the remedy they chose was not to get rid of the mandatory minimum, but basically to make it so Congress has to pay anyone who is sentenced according to that mandatory minimum, the argument there is Congress would very, very quickly capitulate and just do the plan to avoid continually paying everybody. But the net benefit is that you revitalize the private right of action, which secretly is what that Bivens thing in the courts generic is actually about, since the Bivens thing is about, private rights of action against government officials. So technically it's a little bit different for some reasons I'm not going to get into, but that's kind of the net benefit that you would claim there. There's also some counterplans that are not really agent counterplans, but compete off of the process of Congress passing an act. One is the treaty counterplan. A treaty is only signed by the Senate. It's not a bill, it's not a statute. So a treaty is arguably not an enactment. You can pass a treaty that only binds the US, it's self-executing, so it has the force of law. You have the Senate do it, you have the president sign it, and the net benefit is that the House doesn't have to do anything, and you read a politics dissent about the House. Another counterplan that competes off of enactment is the constitutional amendment counterplan. Pretty self-explanatory. You amend the Constitution. You know, pretty simple. Con-con counterplan is a version of this. It just has the States Act, so you have a politics net benefit as well. The legislative veto counterplan. So this is one where basically the thing that the president can do to Congress, which is whenever Congress does an action, the president can veto it, and now Congress has to override it. There used to be a thing where Congress could do that to the president. And so basically the idea here was Congress would pass a law. For example, the president is supposed to, go after drug offenses, the Controlled Substances Act. And let's say the Controlled Substances Act had within it a legislative veto provision. And what that would mean is that any action that the president takes under the Controlled Substances Act, Congress can overrule without passing a specific additional law, but simply through a simple majority. This was ruled unconstitutional under a Supreme Court case called INS v. Chadha, which argued that the legislative veto provisions violated something called the Presentments Clause, which is basically how the bill becomes a law part of the Constitution. Since the president can't veto legislative vetoes, that was argued to be an overreach of Congress's prerogative. And so if you did a legislative veto where Congress overrode a bunch of stuff that the president had done in accordance with the plan, right? So you overrule the same set of stuff that the plan would prohibit. The net benefit of that is you would restore the legislative veto power. Since durable fiat means the court would have to uphold that, legislative veto power is good for separation of powers reasons, for a variety of other reasons, replicates the effect of the plan. Related to the impoundment counterplan from earlier, but there's the defund counterplan, which is just Congress takes the money away from the president to do the AF. This actually arguably competes better off of the reform part of the topic, which I'll get to in a second. A related counterplan is the rescission counterplan, which instead of passing a new appropriation that defunds a certain set of executive branch policies, it rescinds part of an existing appropriation. So basically it claws back part of an existing appropriation. And that's a process that is very rarely used, and you could argue that that is a process that would be good. The filibuster counterplan is another Congress-related counterplan. This counterplan has the president push for the plan, the House pass the plan, the Senate introduce the plan, and then the Senate filibuster it. So filibuster is a thing that the Senate can do which basically blocks something from happening unless it passes something called a cloture vote, which has a higher threshold than the simple majority that is required to pass a law. It functionally makes it so to do anything, you need 60 votes in the Senate. But so after the Senate filibusters it, you punt the case to the Supreme Court. And the Supreme Court rules that this use of the filibuster is unconstitutional. And so it competes because this set of steps has not actually done the plan quite yet. The Senate still has to vote yes. So the presidential advocacy for the plan is supposed to help with that, but that's kind of the say yes component that you still have to win, and the net benefit is that the filibuster is undemocratic, and the filibuster is bad. Final counterplan that I'm going to talk about, which is counterplans that compete off of enact, is the soft law counterplan. This is a catch-all for an enormous variety of stuff, but the general idea is it gets at the same interbranch bargaining theme that I was discussing earlier with the court-threatened counterplan, but this counterplan basically has Congress do a variety of things to kind of cajole the executive into doing the plan, and it replicates the effect of the plan since the executive is doing the same policy change, and Congress has very vociferously kind of declared its support for the plan occurring, both incentivizing it through the use of various sticks and, through public statements that declare that Congress really wants the plan to happen. This can include sense of Congress resolutions, which are basically non-binding resolutions that state Congress's intent. It can include threatening the president with a wide variety of sticks, such as the threat of impeachment, such as the threat of defunding, such as, the threat of a variety of other stuff. A specific variant that I think people could get some benefit out of is stuff that threatens officers of the executive branch with various congressional penalties to get them to change their approaches. So, little known fact is that, well, maybe this is not that little known, but it's something I didn't know until very recently, which is that, first of all, so Congress cannot directly fire executive branch officers for any reason, from my understanding of what I read. But what they can do is they can remove them through several other mechanisms. One is they can impeach them, the procedure for which is very similar to the procedure for impeaching and removing the president. And so one thing that you could do is you could have Congress threaten to impeach and remove Bill Barr unless Bill Barr does the plan. Another similar thing is you could threaten Chad Wolf, I believe is the name of the current DHS guy. So you could change a lot of internal law enforcement stuff by threatening the acting Secretary of Homeland Security. And actually, the Secretary of Homeland Security is currently not a Senate confirmed official. He is, acting. So he's appointed in an interim capacity by Trump. And so Congress actually has even more that they could do to him. Like they could literally just remove him, or they could just appoint a replacement. Or I guess Trump would have to nominate one first. But there's a lot more basically capacity that they have. So you could threaten various officers of the executive branch to get them to do stuff. Another thing you could do is you could just abolish the office of that secretary. So you could abolish the office of the Secretary of Homeland Security, or abolish the office of the Attorney General. And so that kind of set of stuff gives Congress some leverage over other components of the executive branch that are not typically talked about. A final genre of stuff that competes off of enact is the kind of counterplan that I don't know that it has come up enough for it to have a single name. I'm going to call it the grand bargain counterplan. But the general idea here is we're getting into the debate about whether comprehensive reforms or incremental reforms are better. And what this counterplan does is it does not do the plan unless the plan passes as part of comprehensive criminal justice reform legislation. It then puts comprehensive criminal justice reform legislation that includes the plan on the floor of Congress. And it sometimes does some extra stuff to get that thing to pass. So, for example, it has key senators give speeches in support of the compromise legislation of the comprehensive law, or it has the president support the comprehensive law. And the argument is that comprehensive bill will pass in a world of the counterplan, but the plan derails that because incremental reforms trade off with comprehensive reforms for a variety of reasons. And the comprehensive reform is good for, whatever, mass incarceration, key to solve inequality or the economy or whatever. It doesn't really matter. You just read the advantage to the big topic F as your net benefit to this counterplan. So that's kind of my counterplans that compete off of the mainstream of the counterplans that compete off of enact. I guess there's one more category that I'll go into very quickly because it's kind of process counterplanning, but not super process counter. No, I guess, no, it's fine. I'll just talk about these. So these are counterplans that fiat interbranch fights. The most popular example of this that has come up recently is the impeachment counterplan. So this is Congress passes the plan. The executive says they won't do it. Then Congress impeaches Trump for refusing the plan. And then you say that would lead to a removal of Trump as long as there's an actual basis because Trump has violated a law. And the plan would happen after that because Congress has very clearly signaled to the president that, the plan would not occur. Or if the plan doesn't occur, they would get impeached. A related version of this is you just remove Trump for not doing the plan without passing a law of any kind. And then that also leads to executive action. And you could also say there's a follow-on argument that it would be codified afterwards by Congress. Some other examples of presidential refusal stuff that are a little bit less nuclear option-y include the signing statements counterplan, which has, Congress does the plan. The president signs it with a signing statement that says he won't refuse it because he thinks it's unconstitutional. Case gets sent to the court rules signing and then you would argue that the court would rule signing statements are unconstitutional and therefore the plan happens. Similar example is the line item veto counterplan. You do the plan, the president line item vetoes it, it gets sent to the court, you argue that the court would invalidate the line item veto, and that's good for, whatever reason, separation of powers. The line item veto is when you use the veto power to veto part of a bill, which is, pretty much everyone agrees that's illegal. Okay, so that's that's enact counterplans. Anyone have any questions about all of that? I know that was a lot. Yeah, how does the grand bargain counterplan compete is the question. So the grand bargain counterplan competes because it passes nothing. You just put the plan as part of a broader legislative package on the floor of Congress. If no one does anything after the counterplan happens, the counterplan just dies on the floor of the Senate, or dies on the floor of Congress when the legislative session expires. So since it's basically like a recommend counterplan in that sense, where you just like change the way you change the political arrangements in such a way that makes the plan more likely, but you don't actually do the plan. But it competes off of enactment also, because despite the fact that Congress acts to do something, and whatever the thing that Congress does is certain, which is that Congress puts the bill on the floor of the House and the Senate, that bill is not guaranteed to actually pass. So you do stuff to make the bill pass, which is why there's also the net benefit, which is that if you fiat the plan happens, that piecemeal component of the compromise package happening kills the broader compromise package. Does that make sense? Yep. Other questions? Okay, so next I'm going to talk about criminal justice reform counterplans. So this one is not as fruitful because criminal justice reform doesn't mean very much. One thing it definitely means is changing the rules in some way. So you can't really just intensify elements of the system that exist, arguably, since the implication of the word reform, or the kind of etymology of the word reform, is that you have to break something apart and then reform it or like put it back together. So that has two main implications, although these aren't really process counterplans. One, I would say, is increasing funding without change for something in the criminal justice system without changing the rules for that thing is probably competitive, based on criminal justice reform. And you could probably fund certain components of the criminal justice system more in such a way that would replicate kind of the pattern of outcomes that is created by the plan. Although this counterplan is not great in terms of actually getting the plan to happen, so I don't know how much of a process counterplan it is. Another argument is that it's a competition argument for abolition. So since reform commits the AF arguably to reconstituting the system after destabilizing it, it arguably puts a ceiling on how radical the AF is allowed to be. And so that is both potentially an additional competition argument for the grand bargain counterplan that I described earlier, assuming that your grand bargain compromise legislation is sweeping enough in scope, but it also arguably makes the abolition counterplan competitive. Most judges are probably not going to care about that argument, but it's a thing that exists. Another counterplan is the military justice counterplan, which is you do the plan's reform to the military courts, either through a court actor in order to set a broad precedent through the rationale for that decision, or with Congress, and you say that there's spillover between those forums. The net benefit argument would be something about how military leadership on procedural protection is key to military legitimacy. That one's kind of basic. Another one that I don't think has ever actually been read by anyone, but I've like written a couple of these over the years, but never actually gotten to break any of them, is these things called policy area picks. So the background you need to know for this is that when Congress passes laws, they actually like stamp them by saying which policy area they are part of. And so the last time one of these was in the Kentucky Dropbox was on the climate topic. And on that topic, we had an argument that said environmental policy area laws draw a lot of controversy because the label of the environment is uniquely polarizing and partisan. And so if you just relabel it as a health policy instead of a climate policy, then the result of that is you avoid a lot of political controversy and you create a kind of roadmap for people who want to pass other environmental legislation through Congress to do that, which empowers kind of environmentalism. And so another policy area is criminal justice reform, or is crime. I think the policy area is called crime and law enforcement, maybe something like that. But so that kind of gets to the problem with this counterplan, which is that the policy areas don't really perfectly line up with what the terms on the topic are. So like, for example, on the climate topic, it was environmental law, but since it said pass a climate policy, arguably that lines up in that respect. And here, since we're enacting a substantial criminal justice reform, if you do, for example, a non-criminal justice reform, like if you do a health reform and say that law enforcement is bad for health, then you're technically not establishing a criminal justice reform, you're establishing a health reform. So that would also have a politics net benefit. I'm going to skip over these fancy states counterplans because they're not actually that fancy, and I have some other stuff that I would rather get to. In the United States, might not seem like it has very good process counterplan fodder, but there is one main set of process counterplans that compete off of in the United States, specifically on domestic U.S. rights-related topics. And so this is the general moniker that I would attach to this stuff is the universal counterplan. So this counterplan argues that attaching the phrase in the United States to the plan is not a negative modifier. So it's not saying we're limiting the effect of the plan, we're not including outside of the United States, or we're not including foreigners. It's actually a positive modifier in that it connotes a set of functional, procedural, like legal bureaucratic structures that regulates eligibility for the plan. And so in this context, the substantive additional right would require additional verbiage that says this right is limited to the geographic United States because, right? And so the universal counterplan is a pick out of that additional substantive functional language that limits the right established by the plan to the United States and then expands that right globally. This would have a direct jurisdictional effect on places that are under U.S. jurisdiction that are outside of the United States, arguably Guantanamo and arguably U.S. military bases and embassies. But it also has arguably extraterritorial effect, where you're just declaring that international law requires something, and that interpretation is global in scope. So the right is arguably extended to a bunch of other countries, which, you know, is something that has positive perceptual benefits. It is something that functionally solves more. It obviously does the whole plan because it, you know, literally does the whole plan, except arguably for the part that clarifies that the plan is limited to the United States. This counterplan has a very tenuous competition argument, I would say. But that's kind of what you can do within the United States. Any questions about that? The last chunk I'm going to talk about is the courts before we wrap this up. Okay, so Quartz counterplans. So this is stuff that clashes with Quartz affirmatives, obviously. Before I get into this, I'm just going to briefly mention that there's one kind of Quartz counterplan that interacts with the whole topic, which is the strike down counterplan. That's where you rule that the plan is illegal for some reason to counterplan in a disad. The common reasons for doing this are, you could, on this topic, the spending clause is going to be really big. So spending clause is basically when Congress uses its spending power to get states to do stuff. Basically the QPQ counterplan that I talked about above, where you condition some funding or to get the states to do a thing. And so you could either strengthen or weaken the spending power, where if the plan is enforced through conditional spending, you could strike down conditional spending and say that that's bad for federalism. If the plan is literally just a mandate that does not have conditional spending attached to it, you could strike that down for anti-commandeering, say that's bad for federalism. And then in either scenario, you could do the plan through the other of those two mechanisms and say that that's better for federalism. Another one that we have written before is the necessary and proper clause. So you would say that the necessary and proper clause of the Constitution is the one that gives Congress implied powers. So not only does Congress have the ability to do stuff that the Constitution spells out, which is the enumerated powers, but the necessary and proper clause says Congress can also do whatever is necessary to exercise, whatever is necessary and proper to exercise those other authorities. And so this counterplan says that the plan is necessary for exercising those authorities, but it is not proper for exercising those authorities. And that limitation is good for separation of powers, and it's good for federalism. So some other courts counterplans. There's some courts counterplans that link to courts apps no matter what, and then there's some courts counterplans that only link because of unforced plan writing errors. So the first one that I'm going to talk about is the sunbursting counterplan. So this is one that I teased in the elective description. This counterplan is a little complicated. It refuses to do the AF now on the basis of deference to reliance interest. What that means is there are people who are counting on the precedent that exists now for a variety of things. Business decisions, they've spent money under the assumption that precedent is true, etc. The plan's ruling would be unexpected and disruptive to those people if it happens without a warning. So the Supreme Court is like, out of consideration for that factor, we're not going to do the plan now. However, we are going to announce that the plan is correct. So in the future, if someone else brings a case about this issue, we are going to then do the plan. The final thing the counterplan does is it does not deny cert. So cert is the mechanism by which cases get from lower courts to the Supreme Court. So they get from the lower courts to the appeals courts or the circuit courts. And then from there, the only cases that get to the Supreme Court are the ones that the Supreme Court proactively agrees to listen to, or the cases for which the Supreme Court grants cert or certiorari. And so basically what that does is the next time that a case about the plan comes up, the court will hear it and they will do the plan. The net benefit to this is stare decisis, which connects to court legitimacy. So it's a much more kind of reasoned and gradual process of overturning. You warn everybody in advance. So the doctrine of caring about precedent is much less flagrantly violated by the counterplan, which is better for court legitimacy. It also avoids a dishead called sua sponte, which is basically an argument that says it's bad for court legitimacy when you rule on stuff when you rule on issues that are not in front of the court. So basically when there isn't a test case. So the plan does stuff without a test case because it does it immediately. The counterplan waits for a test case to show up. There are some court versions of other counterplans that exist that I talked about earlier. One is the court's version of regneg, which is the court requests briefings on the issues in the plan from a variety of amici, which are friends of the court. And so basically what this does is you get a very broad spectrum of people to come and explain to the court, make a set of legal arguments about the plan. And if you broaden the scope of who is allowed to do that, then that's you're consulting a much wider scope of people. And you're also broadening who gets to count as an amicus. And so that has benefits for judicial expertise. And so arguably that results in positive effects. There's also courts' versions of other counterplans that are more directly transposed. There's judicial referendum, which is the court asks for a referendum of the public. There's also judicial sunsets, which is something I didn't talk about earlier, but that's a counterplan that competes off of durable fiat. And it says, we do the plan, we're going to revisit the plan 5 years from now, and we're either going to modify it, we're going to keep it, or we're going to throw it out. And that doesn't do durable fiat, which arguably comes from the word resolved. And so that, that results in, better policy or like less. So in the judicial sunsets context, there's an argument that it reduces court clog, since people will be less invested in challenging it immediately if they know that it might go away automatically, on its own in a couple of years. I'm basically out of time, so I'm going to stop there if people have questions. I want to give you a second to migrate to your next elective. In the YouTube video, when I upload this, I'm going to link to a document that has a comprehensive list, which you all can feel free to Slack me about or ask me questions about what they are. My list does not have very many explanations in it, but yeah. All right, nice. Thanks for listening to me rant about process counterplans for a while, which, as we all know, is my favorite part of debate. And go to your next electives.